Here, stop at the first convenience store and ask somebody how you get to Nashville.
Exactly.
Just let me tell you.
At this point, all the witnesses have been examined. It's now time for closing arguments.
Thank you. I'm sorry.
Please proceed.
I'm sorry, Your Honor, I jumped. I guess I meant, like everybody else, we're anxious to figure out a way to get home. I hope this commission doesn't lose sight of the issue at hand. There was a complaint, an action. It doesn't say a formal complaint. It doesn't say anything. It says, has there been a complaint against you? Doesn't even say a verbal complaint. It says nothing. The question he had to answer was, is there a complaint? Has there been a complaint against you? The answer was yes, and he answered no. I don't care how you characterize it. There was a complaint, and he knew there was a complaint because he went to Nashville to talk about the issues. Regardless of whether you believe he didn't sign that consent order or not, although I would submit to you that, yes, his signature is different, but that signature is identical at least one other time. But let's say he didn't sign it. Let's say that he's right in that the Commissioner Flowers and the attorneys manufactured this thing, and then let's say that they're perpetrating a fraud by putting it on their website even, saying that this is a document of the Department of Securities that was signed. Let's say it's all a big lie and they're promoting it. He still knew there was a complaint. There were issues against him when he had his security license. That is a complaint. And he lied not once, not twice, 3 times. Do we know he has an ability to tell you the truth? He sat here and lied earlier today when he said that all of those agents that was working with him had been released and sent to another firm. A bald-faced lie. The man doesn't know when to distinguish truth from fact, except for when he can manipulate it to help support whatever point of view he'd like you to believe. This is who's practicing out here. This is an agent who's out there, and yes, he hasn't had any other complaints, but this is an agent who's out there practicing. On top of the lies, he was sent a notice of this in April. When does he bother to finally file a response? In August. Where in the law does he have that luxury? Did he ask for additional time because he was having issues? No. Did he do anything to protect his license and show that absolutely this is a big mistake? No. Does he have an attorney here? No. Did he have an attorney contact me? No. I had not heard from him at all until today. You, as a commission, must decide whether or not he's telling the truth on what he knew or didn't know. But I submit to you that he knew there was actions and complaints filing on security. And indeed, the AG's office is attempting to collect now, although I'm not sure how they can do that if it internally is a fraudulent document posted fraudulently on the website by the Department of Securities. But they are pursuing it at this point. The law says that you can discipline a licensee for various things, including you can discipline a licensee who has failed to file a response within the 10 days as provided by your law, that you can find that an acts and conduct when he got his license was obtained by false representation or fraudulent act, that it was obtained by fraudulent act by making a substantial and willful misrepresentation in his application, that he had violated, and he has, any provision of this chapter, including the division about responding within 10 days, that his conduct entirely has been improper. In 2004, he was a licensee with Securities Division, and there, at the very minimum, was an issue and a complaint from people saying he did something. He had a responsibility to report that to this commission before he got his license, and he didn't. I'm asking this commission today to consider his statements, his inability to tell the truth, his actions, and I'm asking this commission to not only assess him a civil penalty, but to revoke his license and to charge him with all the cost of this hearing matter. Thank you.
Thank you. Would you like to make a closing argument, Mr. Vaughn?
I'm here today with the events surrounding, in my case, it is the events surrounding the consent order. The burden of proof was on the state to prove that I signed the consent order. No one has provided that to reflect that I signed it, other than a fax copy of a letter that was sent from the Tennessee Securities Division in-house. Once, just looking at what the state has sent me, you can go and look at your own, on their own documents. Everything that has come back into their office is date stamped. Everything that's mailed out that came back in from the PSI stuff is date stamped. I would imagine the Tennessee Security Division date stamps everything that is mailed back to their office as well. You don't see a date stamp on that signed consent form. Only thing that you do see is a 615 number that shows where it came from. There's no date stamp to show that they sent that to me and they received it back. If so, why isn't a date stamp? I'm not an expert on signature examinations at all. And I'm not sure if anyone else in this room is, to be able to put their neck on the line to be able to reflect it. I'm not sure how this came about. Yes, I am guilty of not replying in that 10-day period of time. But if you put myself in your shoes and this is your livelihood, I have a daughter and 2 foster kids that I am supporting, and I received something of this magnitude that I know I did not sign. I wanted to get to the bottom. I pulled every kind of record that I could go online and find. I even called the Tennessee Securities Division. I needed to be able to find out, how did this come about? This was the first of my knowledge. On page 16 of that consent agreement, you will read below, and this is to answer Mr. Alexander's question about a formal hearing. It says, by the signature affixed below, Adrian Alibond affirmatively states that he has freely agreed to the entry of this consent order and that he waives the right to a hearing on the matters underlying this consent order and to a review of the findings of fact. That's what I had. I had a findings of fact meeting with them about 8 months after I was no longer employed with an active financial advisor license. I was no longer employed by a firm. I was no longer actively meeting with anyone. The only meeting that they could say that the state of Tennessee, the Securities Division, they had with me was a findings of fact meeting. That does not constitute formal charges. And that's why, to your point, that's why I did not felt compelled to say that that was a formal charge, because that was all that I put up with, was the fact of a findings of fact. And it states it right here. And it states that's why we did not have a formal hearing like this. And it states that we had a findings of fact. And that's all that I had with them. Okay, how did this come about? I just found out in 2012. I don't want to have to pay $20,000 to the state when I don't do anything. But I can tell you this, if something of this nature, if I had the ability to be able to afford an attorney to come to Pickwick, I don't live here. Any attorney that I called that was going to take this whole day was going to be a whole entire commission that I don't have in order to be able to come here and sit with me. I don't have that ability to do that right now. And hopefully, and I'm pleading that you all understand where I'm coming from in the fact that I did not try to deceive anyone. This did not take place 6-7 years after the fact. They said that I signed this on July 21st, the order was entered on September 2nd, 2004, but somehow this shows July 21st, 2004. Why it took a month and a half for it to be applied, that's a good question. That took just as long as it took for me to find out where all this came from. My whole point is, yes, I did take longer than the 10 days. I can acknowledge that. But I did not have any formal charges or complaints brought against me at any point while I was employed or even after I left the company. I met with them one time and it was a fact-finding mission. And that was the last that I heard until I received this from Trek. And that's when I got on board to try to find out what was going on. And that's when I received that letter in states to the $20,000. And of course, they're telling me that this is what's owed you. Well, I could not afford to have to when I make the commission, I will fight that because I don't want to have to give money away. I'd rather set some kind of arrangement up with them and be able to get my money back once this is clear. But there is no, I just cannot accept the fact that this order happened and there's no proof to show that it was date stamped when it was mailed back, that it was done in their presence. If it was done in their presence, then why is it dated September 2nd, 2004? It's dated July 21st, 04. It's not date stamped. It's not faxed from everything that I have sent in to the state has the company's name and a telephone number that I sent to them. The same number that has been in existence that my dad started in 1990. That is not on anything. I hate to plead my case in this way and to have you all sit here. Had I known this, had I known that, I would have honestly answered that and just would have taken my chances. 9 months after I supposedly signed this order, I'm back going to the same state agency that has so-called barred me from being an affiliate. I have a degree in finance. Series 7 is one of the hardest examinations. They put that on the same level as the bar exam. It's one of the hardest things. Only 24% of people pass. I passed that. I'm not a dumb person. I'm not an honest person. I mean, I try to look out for them. That's why I have 2 foster kids. And I'm just looking for the commission to take some kind of an approach to be able to look, just from my point of view, to be able to see. And yes, I'm guilty of not delaying the response. But again, something of this nature was important. I needed to get to the bottom of it. And I appreciate any kind of lenience. I'm severely hurting out here in this industry, and because I can't work and I need to be able to support my family, and I'm just looking for any kind of compassion from my side, from my standpoint. So I thank you.
Thank you. Does either party have written proposed findings for the commission? Okay. And have you shared those with opposing counsel?
Give it to him right now.
Okay. The parties have an opportunity, Mr. Bond, to submit proposed findings to the commission to help them in their deliberations. The state has chosen to do that. Yes, you may present them at this time. Have you chosen to do that, Mr. Bond? Have you chosen to bring with you proposed charges for the commission?
No, I haven't.
Okay. That's fine. I'll let the commission study those proposed findings for a little while, and then I'll officially charge the commission. All right, it looks like the commission has had a chance to review the proposed order. I'll begin the charge. The commission has now heard the proof in the case of Adrian Bond, license number 299968. In the bond matter, the state is seeking that the respondent be disciplined for allegedly violating the Tennessee Real Estate Broker License Act of 1973, found at Tennessee Code Annotated 62-13-101 et sec, particularly sections 63-13-312B, 1, 14, and 20 as follows. B, the commission shall have the power to refuse a license for cause or to suspend or revoke a license where it has been obtained by false representation or by fraudulent act or conduct, or where a licensee in performing or attempting to perform any of the acts mentioned herein is found guilty of 1, making any substantial and willful misrepresentation, 14, violating any provision of the chapter or rule or order of the commission, 20, engaging in any conduct which constitutes improper, fraudulent, or dishonest dealing. The state also relies on TCA 62-13-313A2, which states that the accused shall, within 10 days, file with the commission the licensee's answer to the complaint, a copy of which shall be transmitted to the complainant. TCA 56-1-308 permits this commission to assess civil penalties for violations of statutes, rules, or orders. TCA 56-1-311 and Rule 0780-5-11-.01 also permits the commission to assess the respondent the actual and reasonable cost of investigating and prosecuting this matter. As sole and exclusive finder of facts in this matter, you must conduct open deliberations and make findings of fact and reach conclusions of law based on the facts found, determine the penalty, if appropriate, and determine policy reasons for your decision. You must make findings of fact based solely upon the evidence presented before you in this hearing. This evidence includes the testimony of witnesses, and any exhibits introduced, the notice of hearing, and the proposed order filed by the state is not evidence, but may be used as a guide to assist you in making your findings, but it's the sole responsibility of the commission to make its own findings of fact in this matter. The attorneys and respondent representing himself have argued their respective theories of this matter. The statements of counsel or of the respondent while serving as counsel are not evidence, but are merely arguments to persuade you to see the evidence in the light most favorable to their position. Give such arguments whatever, if any, consideration you feel is appropriate. In making your findings, the commission must determine the credibility and weight to be given to the evidence presented by each witness. If there's conflict in the testimony between witnesses, it is the responsibility of the commission to reconcile those conflicts if possible. But if it is impossible to reconcile the conflicts between witnesses, the commission must make the determination as to which witnesses to give the most credibility. In reaching such a determination, the commission should bear in mind the following principles of law. The law presumes that all witnesses who are sworn to the oath testify to the truth. It is the obligation of the finder of fact to attempt to reconcile any discrepancies in the testimony between witnesses, but if it is impossible to do so, then it's necessary for the triers of fact to determine which witness speaks the truth and which witness has stated a falsehood despite his or her oath. In determining which witness is believable, the commission members, as fact finders, have wide discretion. However, the commission members should consider in determining the truth the witness's interests, if any, in the outcome of this matter, their good intentions, their seeming honesty, their respective opportunities for personal knowledge of the facts about which they are testifying, and their conduct and demeanor on the witness stand. Before the commission should consider any possible disciplinary action, the commission must first determine whether the state, the petitioner in the bond matter, has met its burden of proof by proving the charges that it has brought by a preponderance of the evidence. If the commission finds it helpful, it may weigh the evidence mentally on the scales of justice. If the scales tip in favor of the state, the commission must find for the state. If the scales tip in favor of the respondent, the commission must find for the respondent. If the scales are evenly balanced, the commission should bear in mind that the state has the burden of proving the charges. The respondent does not have the burden of proving that he is innocent. If after a full and impartial review of the evidence presented to you, the commission feels that the state of Tennessee has carried its burden of proof by a preponderance of the evidence, the commission must then, based on its findings of fact, determine whether the conduct of the respondent is such that he is guilty of either one, any, or all of the charges. If the commission finds the respondent guilty of a charge or charges, then the commission may take appropriate disciplinary action. If after a full and impartial review of the evidence presented to you, the commission may find, for example, that the respondent has not violated the Real Estate Brokers Act and its accompanying regulations. It may find that the respondent has violated the Real Estate Brokers Act and that discipline of the license is warranted. It could find that the respondent has violated the Real Estate Brokers Act, that discipline of the license is warranted, and that civil penalties should be assessed. The commission could also find that the respondent should pay the costs of the proceeding in addition. In assessing the alleged violations and appropriate penalties, if applicable, the commission may consider any evidence that the parties have introduced, including but not limited to whether the conduct was or is of a continuing nature or a one-time occurrence, whether the amount imposed will be a substantial economic deterrent to the violator, the circumstances leading to the violation, the severity of the violation and the risk of the harm and the risk of harm to the public, the economic benefits gained by the violator as a result of noncompliance, and the interests of the public. Additionally, the commission may consider what it has done in previous similar matters for comparison purposes. I mentioned these examples of possible discipline for illustration only and not in any effort to sway the commission in its determination. From time to time, I may have been called upon to make rulings of law and procedure during this hearing. The commission alone must make the decision regarding the merits of this matter and must not draw inferences concerning any opinion that I may have in this matter from any statement or ruling that I have made. Chairperson Stevenson, please proceed with the deliberative process, establishing findings of fact, conclusions of law, and policy reasons for your action.
You've heard the charge by Judge Williams to us and what we are charged with to do in this matter. And in the matter, as we proceed, of Adrian A. Bond, docket number 1218-120574A. The chair is now ready as we deliberate and as we move into our findings of fact in this matter. And then after that, then we'll determine the conclusions of the law and what penalty would be appropriate in this matter. And then after that, we will develop a policy statement in this matter that will be satisfactory as to what has transpired.
Mr. Chairman,
Commissioner Northern.
in the matter of Adrian A. Bond, docket number 12.18-120574A, complaint number L12-REC-RBS-201-2008-661. I move that the state has in fact proven that the respondent submitted an application for licensure on 3 separate occasions, those being July 19, 2005, March 5, 2008, and January 13, 2012, wherein he answered no to questions 2 and 4, which read, have you ever been refused a license or had a license revoked, suspended, reprimanded, or fined by any federal, state, or local government? Do not include motor vehicle licensure. And 4, have you ever had a complaint filed against you with any regulatory agency or with any court?
I second.
You've heard the motion by Commissioner Northern. You've heard the second by Commissioner DeShara. Any discussion on the finding of fact that has been proposed and made by Commissioner Northern? Any discussion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries unanimously.
Mr. Chairman, as a result of Mr. Bond answering no to questions 2 and 4, the state granted a real estate license on 8305 and 32608, allowing Mr. Bond to practice real estate in the state of Tennessee.
Second.
Had the motion by Commissioner Northern, seconded by Commissioner DeShara, as to 2 facts that have been proved by the state. Any discussion on this? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries.
Mr. Chairman, I move that with regards to the application for brokerage upgrade for Mr. Bond, the state did not issue the license for broker, and at that time issued a consent order on April 10, 2012, regarding Mr. Bond's answer of no to questions 2 and 4 in the 3 applications previously mentioned.
Second.
You've heard the motion made by Commissioner Northern and seconded by Commissioner DeShara. Any discussion on this motion? Hearing none, all in favor say aye. Aye. Opposed, no. Motion carries unanimously.
Excuse me.
Mr. Chairman.
Excuse me, I did not present proof that there was a consent order sent in April of 2012, and I just want to be sure the commission understands.
Right, I was surprised by that
Yes.
also. I don't know what's contained in the exhibits. I thought maybe they got something out of the exhibits that led them to that conclusion.
Let me rephrase it. Notice of consent and charges.
Notice of
Would that be
Notice
correct?
Notice of
hearing.
hearing and charges.
No,
Notice of,
it was a complaint that was sent. That was the proof. There was a complaint sent in April 2012.
a complaint from the Real Estate Commission with regards to Mr. Bond's answers to questions 2 and 4 on the previously mentioned 3 licensure applications. I stand corrected.
Well, then that last motion,
We rescind.
somebody make a motion, rescind the last motion.
I make a motion, we rescind the last statement, finding of facts.
Motion and Commissioner DeShara, second by Commissioner Haynes, that we rescind the previous motion made by Commissioner Northern.
Let me correct the motion.
And let's vote on this rescission. All in favor to rescind the motion previously, say aye. Aye. Opposed, no. Motion carries. Commissioner Northern.
I move that the State Department of Revenue Real Estate Commission did issue a complaint to Mr. Bond with regards to his answer to questions 2 and 4 on April 10th, 2012. And if I can continue, Mr. Bond did not respond until April 18th of 2012, and failed to answer the complaint until August 15th of 2012.
Have a motion as to additional findings of fact. Do I hear a second?
Second.
Commissioner Alexander seconds that motion. Any discussion or comments on the motion on the floor? Hearing none, all in...
Excuse me. I'm very sorry to have to correct, and I'm sorry, but I want to make
Please.
sure I understand this. You're saying he responded on April 18th?
The information I have says that he responded by email.
He acknowledged.
Well, isn't that response?
Receipt. Yeah, he acknowledged receipt, but that's just.
Acknowledged receipt by
Because it is.
email,
Yes, okay,
with an answer being submitted on,
okay.
or received on August 15th. Would that be correct?
Okay, let the record show that the motion is that on or about April 10th, 2012, the respondent was sent a copy of the complaint and had been opened by the Real Estate Commission. He acknowledged on April the 18th a receipt of said complaint and then answered that complaint on September,
No,
August.
15th.
August 15th. August,
Well, commission
August.
received on 15th, correct?
That's correct.
August 15th, 2012. You have heard this motion, and the second, who seconded that motion?
Commissioner Alexander.
Commissioner Alexander. Any discussion? Hearing none, all in favor say aye. Opposed, no. Motion carries.
Mr. Chairman, I make the motion that Mr. Bond, as a result of having received licenses to practice real estate beginning in 2003? Is it 2000? Would that be correct?
2005.
2005,
Yeah, July.
has in fact engaged in the activity of real estate since that time and up to, according to testimony, receipt of the complaint, or I'm sorry, receipt of notice that the firm had been flagged and put on, what's the term we use?
Problem status.
Problem status.
Second.
Heard this motion, and a second. Any discussion or comments?
Did we have a date on that, when he was actually put on problem status?
I believe Ms. Maxwell's testimony gave us a date, but I did not make a note of it.
Is that a question that we could ask, or we just have to skip over it?
If you feel it's relevant, yeah.
Well, you could skip over it, or you could reopen the record if there's a motion to reopen the
I
record.
mean, in this matter,
I'll do
it
whatever.
was in 2012.
Yeah.
So from 2005 until the firm was put on problem status, the firm was put in problem status sometime in 2012. Whatever that date was, I don't think is all that relevant. It's just until that firm was put in the problem status. He had continued to practice real estate. But now there was a brief period in there when his license had expired and he retested in 2008.
There wasn't really any proof put on whether he quit practicing real estate during that time or not.
That's true. And all the proof showed that his license expired in '07. He reapplied on March the 5th of '08 for another license, affiliate broker's license.
Well, the complaint was open on 4/10/12, so
But I mean, during that time period from '05 till he first got his license until the firm was just put in problem status, he was.
would they have put it in problem status before they opened the complaint?
I don't know.
Or Because he applied for his broker's license.
There was no testimony given as to whether or not Mr. Bond stopped practicing real estate during that time period, but he didn't. We do know he did not have a license for a brief period of time, or he would not have retested.
Yeah, he took his test in January, February, and then in April, they filed a complaint.
So, but anyway, you've heard the motion that Commissioner Northern has made about Mr. Bond's practicing of real estate up until his firm was put in a problem status in 2012. All in favor of this motion, say aye.
Aye.
Opposed, no. Motion carries.
Mr. Chairman, for discussion, the state has put on evidence that would indicate that Mr. Bond answered falsely to those two questions 2 and 4 as a result of a consent order from the Securities Department. He has offered evidence that he didn't sign the consent order and was not aware of it. That, I believe, would be a point of discussion. I don't want to impose a motion in regards to that without there being discussion, because I feel my opinion is different from those other commissioners here.
I think that probably is a issue that he needs to address with the Securities Department of whose signature it was. I think that probably if you go back and we heard our own staff say that she had received a signature at least one time by fax. Whether it's his signature or not his signature, he certainly was aware that he had problems. I erred in the fact that there was not a formal hearing, that you cannot have a formal hearing without offering something, and that's why that this order was issued by the securities. I erred in that you've got to offer a licensee by consent order before you have a formal hearing. So I erred there. But you knew about it. You admitted that you came to Nashville and you all talked. And there is information in the packet of where these folks originally sent in and what started the consent order with the department about your other license. So I know that you knew that you had a problem. You also told me that you did not admit your guilt. But why would a person tell you that you were going to start making payments on the $20,000 fine on the consent order that you say you didn't sign? I don't. And if I knew about those and I were in your shoes, well, I had an attorney, what I would be trying to resolve that. But I'm a lot like Isaac. I think that's another issue. I think that goes back to, and he needs to get that, and that's an issue with the department, the other department where you had the other license. But we also came up with the fact, even though he admits that he owns a company, you don't have to have a license to own a company, but they didn't have a principal broker. They don't have a principal broker now. He indicated that he had transferred those licenses to another firm. You go to the website today, and his firm, or that firm, still has agents in a problem status, but still assigned to his firm. Now, he tells me, and it's certainly very evident, that he's an educated man, that he's smart. So that makes it harder for you to present to me and prove to me that you didn't know what was going on. Now, I'm like Isaac. You hadn't proved to me. I don't know about the signature. If you look at the signatures, you look at his signatures, and I've looked at them. I've looked at them repeatedly on all the different forms, including the consent order. The others, he's kind of like me. He write one way one time and another way another time. But it certainly looked to me on the consent order, somebody did a pretty good job of forging your name, if that's your case story, and you ought to stick to it if that's what you want to do. But that's all I've got to say for discussion.
Along that same line, Commissioner Orr, when you read that question, number 2, have you ever been refused a license or had a license revoked, suspended, reprimanded, or fined by any federal, state, or local government? Whether he signed, which he says, like Commissioner Alexander says, whether he signed that consent order or not, he'd been to Nashville. He knew. He was fully cognizant of the fact that he had had issues with the Department of the Tennessee Securities Division. He had issues, and like Commissioner Alexander said, whether he signed it or whether he didn't, if he didn't sign it, then forgery is a major issue, which there's no statute of limitations, I don't think, on forgery, and something that he may need to address if he didn't sign that. But anyway, the testimony in my mind, he was fully aware that he had issues, had been reprimanded, and had been license revoked, suspended, reprimanded, or fined by any state or federal, state, or local government. He was fully aware of that, and he said no, that he had never had anything like that happen. And that's all I got to say.
Well, I disagree with you. I don't think he was fully aware, and the way I read the general stipulations, it says that the consent order is not even accepted till the commissioner signs it. I'm not sure how this department, I know how we go about doing this. I don't know how this department goes about doing this. I don't know if they sit down and they investigate and they decide, okay, well, in our opinion, this is what's happened, so let's get a consent order signed and go on. I'm still not sure how that's done. I don't know that anybody proved to us how they do that. And I have real concerns with even the back page is not even the same typeface as the rest of the document. And if it was so important to have his signature on it, why wasn't it over here with Ms. Flower's signature? I mean, those are just my questions with the document. I think both sides have been credible with the evidence. Both sides have put on but I just have real questions with this document. And I don't know why it is the way it is, but the credibility of the document itself just really concerns me. The discrepancy with the dates. It just concerns me. It concerns me that somebody doesn't know that they owe the state $20,000 for 8 years, and why the state hadn't sent it to a collection agency a long time ago and filed something in court.
That's not the way you do that, I don't think.
I don't know if it is or not.
Well, we know we have.
But I don't know. That's my question. That's why I have real questions, because I don't know. I've never had the state file anything against me, so,
Well, when you have a complaint filed against you, you'll act, or at least I did.
I would.
And I didn't wait
think
8
I
months.
would. And I don't know that there's any action, or maybe inaction is action. But those are my questions, and I just have real questions about the document. I think the evidence, there's credible evidence between what both parties have said, but my real question is with the document itself.
Well, I personally don't know that that's for us to decide. I think the biggest issue for us to decide is whether he was actually guilty of fraudulently representing himself when he answered no to questions 2 and 4. He had been to Nashville for a hearing, whether it was formal or informal. He had knowledge that there were people that were not happy with him. Now, that was eventually worked out, and they may or may not have gone away, depending on how you look at it, but he knew there was a problem. I mean, he admitted he went to Nashville and discussed that, and that was just the year before he got his real estate license, so he knew it was out there.
But if I was sitting in his shoes, I'm not sure I would know that that was a formal complaint, or if I would just thought they were investigating something, and if I knew these people, and I knew they were satisfied, I mean, I don't know what I would think in my head. I really don't, and that's why I've got so many questions. I just don't know what I would think.
I feel the same way Commissioner Haynes does, and with regards to whether or not it was a formal complaint or a fact-finding hearing or whatever, I liken it to licensees being called before the association ethics or professional standards committee because there is a need to find out what actually happened. But that doesn't rise to the level of being a formal complaint by the real estate commission. I know we're talking about one body with regards to securities, but at some point there has to be some effort to hear both sides of the story. And his trip to Nashville could well have been an effort to hear both sides of the story and not necessarily a fact-finding, I mean, not necessarily a hearing. I've not heard any evidence that convinced me that there was a formal hearing wherein he was charged and there was a consent order resulting from that. But it just didn't, I didn't see it. Now, whether or not he knew that there was some issues arising from his activities, sure he did. He's already admitted it. But whether or not there was a formal complaint, I've just not had any evidence to show that he knew about it. And if I can't say that he knew about it, then I can't say that he falsified questions 2 and 4. That's my dilemma.
Well, question 4 doesn't say formal complaint. It says, have you ever had a complaint filed against you with any regulatory agency or with any court?
People call Trek, I'm sure, quite often and say people did this, this, and this, but it's not a complaint until they fill out that form. We don't consider it a complaint until they fill out that form. Somebody inquiring does not necessarily rise to the level of a complaint. As I said, I'm not comfortable making the motion that he was in violation because of falsifying. But that doesn't prevent either of you all from making that motion. If you feel that that was in fact.
If, Mr. Northern, if you went to Tennessee Gov or and pulled up a complaint like this man's got on its own on the website, and his complaint is there, like any others that have been filed, I'm sure that we hear, then you can pull them up, and you see. And again, I'm not arguing about whether his signature is his signature or Ford's signature. But if it's there and the commissioner and the attorneys and all for that board believe that enough that they offered him a consent order, it is a flag that there is that he's got a problem. And, Mr. Chairman, I am prepared to make you a motion that we find him guilty of those questions of answering no on his applications and not whether he signed or did not sign what am I trying to say? Proposed findings of the facts on this. I'm not going to do that, but I think he misled this commission or this staff when he filled out those applications, not only once, twice, but 3 times. Plus, he told us that he had transferred those agents. I don't really believe that he's forgot that much. When he tells me that he's an educated man, he knows after business and he looks at the business, and that's my motion.
Now, could you clarify, simplify your motion pertaining to questions 2 and 4 about where it says, that's what we've been talking about. Have you ever refused a license, had a license revoked, suspended, reprimanded, or fined by any state, federal, state, or local government? And then also 4, have you ever had a complaint filed against you with any regulatory agency or with any court? And he voted,
Yes, he's had a complaint filed against him. We filed a complaint against him. You can file anybody when and it came from an anonymous thing when it got mailed to us, faxed to us.
Our complaint was filed after he.
Our complaint was filed when somebody emailed his complaint from the regulatory of the license. That's when, and it came from Memphis fax. That complaint came to the commission anonymously, and it was presented.
You're talking about the consent order, not complaint.
Oh, I'm talking about, yes, the consent order where it was signed supposedly by him and the staff of that regulatory board. And it became, it was an anonymous complaint filed, just mailed in. They emailed his consent order to the commission. And they reviewed it. They saw where they thought, whether it be, they didn't think, they believed that it was his signature and it was the commissioner's signature on it and the staff attorney. And then it was presented to this commission, and we felt that it was a legitimate complaint.
See, Commissioner Alexander, he had already signed the application for broker exam. He signed that in January, and we did not open our complaint against him until April.
I understand that, Mr. Chairman, but he was aware of what had been filed and that the consent order that he was offered. Okay, am I out of time, or we're
gonna switch it over.
Okay, I'll just stop.
Well, we gotta switch.
Let's
It's
switch.
time to change the tapes.
Let's switch the tape.
Gotta switch.